It's so good to see all of you guys for another weekly webinar. I think this is the third one we had now in a row. We've gotten so much knowledge from the past speakers. Today, our topic is Commencing Legal Action by Kelvin Sean Rowe. A little bit about Kelvin beforehand. Kelvin has been practicing law for over 3 years now. He's a very experienced lawyer, especially in matters of civil litigation. So today he will be sharing some nuggets of wisdom and general tips regarding the topic of commencing legal action. Kelvin, over to you.
Hi, good evening, everyone. Thanks a lot, Isaac. Okay, so my name is Kelvin. As mentioned by my colleague, I've been practicing civil litigation for the past more than 3 years. I have experience in different matters of different cases, such as medical negligence. I have experience in bankruptcy matters, probate, debt recovery cases, and so on. Okay, so basically, I'm going to speak about commencing legal action. I feel that a lot of people take this chapter for granted. It is not as simple as many would think. Basically, if you do it wrong from the start, it's not going to go well at the very end. Okay, so let's begin. So I'm going to use not very legalistic terminology today, just so that everyone understands this to be considered before commencing legal action. The brief overview of the writ process, the jurisdiction of each court, the magistrates court, sessions court, and the high court. And lastly, the criteria in deciding the jurisdiction of each court in terms of where do you sue? Do you sue in Kuala Lumpur? Do you sue in Selangor, and so forth? So let's begin. Okay, so there's two ways of commencing legal action, but number one is by way of originating summons, and secondly is by way of writ. So if you start by way of originating summons, basically, in general, the originating summons procedure is appropriate where the dispute concern with matters of law where there's no substantial dispute of fact. In comparison to a writ, the originating summons is faster and simpler. A writ, on the other hand, is normally commenced in most proceedings, and it is mandatory to commence legal proceedings by way of writ. Another way to look at it is that originating summons, or may I use short term in terms of OS, the OS doesn't require witnesses to prove its case or to conclude the case. There's no witnesses compared to a writ where there is always witnesses involved. Okay, next will be the preliminary matters to be considered before commencing legal action. The most important question to be asked: what is your cause of action? Why is it important to establish a cause of action? Because whether is it a claim under tort, is it a fraud, or was it a breach of contract? The reason being is because the particulars which you would have to plead in each case will be different. For example, if you plead fraud, you have to plead specifically, you have to have a particular pleading just for fraud. Okay, and then the cause of action determines the form of proceedings to be taken in court, and it determines the remedy to be granted by court. For example, if you are looking at a cause of action of fraud, you might be looking at recovery of fraudulently transferred property. If you look at breach of contract, maybe there was a breach in terms of the terms of the contract, and you might be seeking damages. Okay, so the next is the entity of the potential defendant. Whether in terms of defendant, if the defendant is an individual, then it's not really of a problem. However, if the defendant is a company, or may I say a sole proprietor, or private limited company, or another term, Senam Berhad, then the name of the name of the party of the suit will be different. For example, like if you are suing a private limited company, then you will sue under the name of the company. But if you are suing as a sole proprietor, then you will sue the sole proprietor in his personal capacity. However, you'll be suing it under the name and style of the company. Okay, the most important thing is limitation, because limitation basically is how long from the date the breach occurred you can sue. So, for example, actions founded on a contract or tort, basically you have 6 years to sue from the date on which the cause of action accrued. That is under section 6.1 of the Limitation Act 1953, sorry. And if you Another example will be a recovery of rent. Okay, that is 6 years from the date on which the arrears become due. A special one would be for fraudulent breach of trust or recovery of trust property, as there is no limitation under section 21 sub 1 of the Limitation Act 1953. Okay, and lastly, a potential litigant must all consider which court it wishes to sue at. Is it the Magistrates Court, Sessions Court, or the High Court? Okay, the next would be basically a brief overview of the root process of what actually happens from day one to day end. So firstly, you will issue the written statement of claim. Okay, then after the written statement of claim has been issued, then you will have to serve it on the defendant. How would you want to serve it? Again, depends on the entity of the defendant. Is it a sole proprietor? Is it a company? Or is it an individual? Then it determines, is it by way of personal service, registered post, or AR registered post? But please note that registered post and AR registered post is different. AR registered post usually comes with a card, and it basically mentions as to whether the the recipient has received the document or not. Once service is effective in terms of serving the writ and statement of claim, then the defendant is required to enter into an appearance by filing a memorandum of appearance within 14 days. All right. Okay. But if so the next question is, did the defendant file a memorandum of appearance or not? If they didn't, then you are entitled to enter a judgment in default of appearance against the defendant. Basically, what happens is that whatever that you have pleaded for, or whatever you have asked for in the court through your statement of claim, will be granted through the judgment in default of appearance. However, if the defendant files the statement of defense, if he has entered into appearance, the next stage is to actually file a defense within a few days, within 14 days as well. If the defendant fails to enter a statement of defense, then you are entitled to actually obtain a judgment in default of defense. Okay. However, if the defendant then files his defense, and when pleadings are closed, the next stage is basically the pre-trial case management. The pre-trial case management is where the court will give directions as to for you to file documents. This is when you start exchanging documents, bundle of pleadings. This is also when each party will then inform the court as to the witnesses which will be brought before the court in trial, and lastly the witness statement. And after that, it will be trial. After trial, there are two options available. Either the losing party appeals against the decision, or the plaintiff the plaintiff will then enforce the judgment obtained. Okay, next. So basically, this is basically the jurisdiction of the magistrates court. What kind of cases that the magistrates court can try upon? So we're speaking about in terms of the civil jurisdiction today. So a magistrates court has the jurisdiction to try all actions and suits of a civil nature where the amount of dispute does not exceed 100,000. So anything more than 100,000, you have to go to the sessions court. Okay, so the jurisdiction of the sessions court is it has unlimited jurisdiction to try running down cases, landlord and tenant disputes, and distress actions. For those who are not so sure, running down cases are basically accident cases, involve road accident cases where one party is suing for personal injury. For example, maybe the person has suffered a broken arm, and so you're claiming damages for that. So that is running down cases. Okay, basically the sessions court has jurisdiction to try other suits where the amount of dispute or of the subject matter does not exceed 1 million ringgit. Anything more than 1 million ringgit, okay, parties have an option. Basically, actually, after 1 million, if you have any claims above 1 million, you are supposed to bring the suit over to the High Court. But parties at times, maybe in terms of cost saving, they might still insist of trying the case in sessions court. So that when paragraph D comes in, with the consent of parties involved to try cases exceeding 1 million. But the award that the court can award the plaintiff is only up to 1 million. So an example would be like, if just say your suit is for 1.2 million, parties can agree to try the case at the sessions court. However, the court can only grant to 1 million, which means that you have to relinquish your 200,000. The maximum that you can go is 1 million. And lastly, without prejudice to the generality of paragraph B, jurisdiction to try all actions of a suit of a civil nature for the specific performance or rescission of contracts or cancellation or ratification of instruments within the jurisdiction of the Sessions Court. Okay, next will be the High Court. So as mentioned earlier, the High Court has unlimited jurisdiction. They can try, it has no monetary limitation, in the sense that it can try cases to 1 million, 2 million, or 10 million, or even 20 million, it doesn't matter. And the High Court has the power or jurisdiction to try to listen to cases involving divorce cases. It can grant orders of bankruptcy or winding up of companies. It can grant orders for guardianship, custody of children, injunctions, specific performance, or even grant of probates or wills and letters of administration. Okay. So the next question is that which court do you sue at? That's a very important question as well, because many cases or not, your suit might be at the wrong court. An example would be the court in Petaling Jaya and Shah Alam. They are pretty much they are in the same state, but they're in the different districts. So which court do you go to? Do you go to Petaling Jaya or do you go to Shah Alam? Okay, so this would basically clear things up. So Section 99A of the Subordinate Courts Act 1948 basically provides the issues to be determined when determining as to where you are supposed to sue. Okay, so a simple analogy would be this: if you just say you have a problem with someone, and you're going to pick a fight with someone, okay. Chances is if in that case you would approach the person who you are going to have the problem with. It's not the other way around. The person with the problem will not come to you. It's going to be the other way around. So most importantly, the cause of action. So let me put a situation. Just say you have a friend, and this friend, you borrowed your car to a friend, but unfortunately this friend stole your car. And just say it happened in KLCC, for example. Okay, so you can start your cause of action, or you can start your case in the court in Kuala Lumpur, where the cause of action arose. Okay, another point you can look at is that just say the defendant, the person who you're going to sue, lives in Subang instead, or maybe Shah Alam. Okay, let's say Shah Alam. So you can also sue him at the court of Shah Alam. Okay, you can sue him at where he resides. However, what happens if you just say there are two of your friends who stole your car? Okay, so basically just say one stays in PJ and one stays in Shah Alam. Then you can choose either one of the courts in PJ or Shah Alam, whichever the defendant resides. Okay, you can also sue on the facts on which the proceedings are based, exist or alleged to have occurred, and for other reasons in the interest of justice. So if the interest of justice requires it to start in that particular court, then it will start at that particular court. The next will be High Court. High Court is governed under Section 23 of the Court of Judicature Act 1964. Again, this is the same approach where the cause of action arose. The defendant or several defendant resides. Where does he live? Okay, this is another important one. Where the land ownership of which dispute is situated. So where there's a land dispute, for example, maybe the land dispute is in Shah Alam, or maybe it's in PJ, or whatever it may be, or Kuala Lumpur, you can sue based on where the land is. Okay, and most importantly, in addition to above, the plaintiff must know that the defendant must not be put to inconvenience. There must be a form of convenience. What does this mean? Basically, you have to sue the defendant based on where he lives and not where you live. It's not on your convenience. You have to put the defendant's convenience in for priority, or as priority compared to yours. Okay, and that will be it for today's webinar. I open the floor for any questions.
Thanks, Kelvin. Yes, any questions, please feel free.
Hi, Kelvin. Can you hear me?
Yes, I can.
Hi, Kelvin. Good presentation. I was just wondering, if I had started my suit in the wrong court, what actually happens to my suit? As in, like, what are the legal consequences to it?
Oh, okay. Okay, that's a good question. Okay, let's see. Okay, let's take the example again for PJ and Shah Alam. Okay, just say you started your suit in the Shah Alam court, but actually, the defendant lives in PJ. Okay, now what happens, right? Okay, it's not fatal, which means that your suit will not be automatically struck off and or struck out, sorry, and everything goes to an end. No, basically there are two things you can do. Number one is that you can transfer the matter on your own motion, which means that you can apply to court to transfer the suit to the PJ court. Or what will happen is that usually the court will order for the matter to be transferred. So I hope that answers your question.
Yes, it has. Thank you.
Thank you.
Thanks, Katrina, for that question. And yeah, a good question. Any other questions?
Hi, Kelvin.
Hi.
Yeah, I was just wondering what will happen if I start my suit by way of originating summons instead of using a writ of summons?
Oh, okay. That would be a serious. That would be a serious problem in the sense that if you started the suit, just say for example, breach of contract by way of originating summons instead of writ, basically it's an abuse of process of court. If it's an abuse of process of court, chances is, I mean, in practice, usually what happens is that the party filing the suit will have to withdraw the suit. They will have to withdraw the whole suit and refile the suit afresh. But if the defendant was not around, if the defendant has entered appearance and so on, chances is they will apply to court to strike off the whole case, being as an abuse of process of court. Okay, so I hope that answers the question as well.
Yes, it does. Thank you.
Thank you.
Thank you for that question. Anyone else? Any more questions on the floor? All right, I will take it that there are no further questions. Thank you very much, Kelvin, for the very informative talk. And everyone here, today we learned a little bit more about commencing legal action. Thank you so much, everyone, for tuning for today's talk. We hope you have a good weekend ahead and join us next week for our next webinar. Take care.
Thank you, everyone.